She wants to go to law school. You do the LSPI. She also does the LSPI program at UTEP. And she's a very good writer, by the way. I had her write some stuff and much better writing than mine, which comes to no surprise to anyone, I'm sure.
No, I think that's the hardest thing. I will tell you, I didn't think I was a very good writer when I got up to the Court of Appeals, but practice makes perfect. I always thought it was something you either had or you didn't have, right? But let me tell you, and then my daughter here in Manhattan, she's an English teacher, and that's all she teaches is writing. So there you go.
Yeah.
It can be learned. That's what I learned.
It's if you read a lot, it helps. But you have to write because it's And I just finished last week. I finished an appeal before the 8th, and it had been a while. I did a lot of appellate work when I was in Houston, and not so much after I joined the PD, but
right.
It's a different beast, one would say. It's very different.
It's technical. To me, it's very technical writing. It's not, it's not, obviously it's not creative writing or not writing for the New York Times bestseller list, but I enjoy it. I guess I enjoy it. I'm still doing it.
That's good.
Yes,
and all right, so well, I guess we're waiting for Mr. McCarthy.
Yes, I believe we are.
Good afternoon, Judge. My name is Madison Cannon-Dingle. I'm the 168th paralegal for the District Attorney's Office. Donald McCarthy is on his way.
Okay, that's fine. We'll just wait on him. That's not a problem. I see Miss Pages and Mr. Avila already, pencil sharpened.
Judge.
I'm just still munching, so y'all ignore me doing that.
Donald McCarthy, apologies for tardy.
No problem. And somebody remind me, did you send me a CV for Mr. Excuse me, Dr. Is it Dr. Galaznik?
Judge, we send it to the prosecutors, but I don't know if you send it to the court.
Okay, I was just asking because sometimes it's helpful, but that's up to y'all if you want to. I listen to the testimony anyway. It's not a requirement. I just want to be sure if you sent me one, I want to be able to look at it.
We will send you one, Judge, if we send it to Mr. McCarthy. And I think we did.
Just so maybe I can follow along.
I believe you did, and I'm checking Mr. Shelley right now. I do believe you did send it to me. I believe you did.
I know I saw Dr. Munson. I know that one was sent to me, but I don't think this one was. If somebody has a minute to forward it to me so I can pull it up and look at it and follow along with the testimony.
Mr. Shelley, I might also need it. I'm going through the emails from you. I don't see it yet.
And I don't see the court reporter.
Not here, Judge.
I'm sorry?
He's not here yet. I don't see one either.
Yeah.
I'll make a phone call, Judge.
Thank you. I appreciate it, Robert.
So it's looking like you did not send it to me. I'm still trying to check everything you sent with attachments.
Yes, let me double check that.
Yeah, thank you. Okay. Okay, I've got everything now that supposedly has an attachment from you. I don't see it. On the other hand, I don't know, you might have sent it on Teams, so I don't know. I'll check that too. But I'm not sure how I would get it to somebody from Teams into email.
Yeah, I don't, I'm not on Teams.
I don't know if I'm capable of that.
No.
Let's see. No, you sent Monson, actually you sent Monson by email and Teams, but that was Monson. Yeah, it looks like not. I mean, I had thought, but I guess maybe I assumed, maybe because I was thinking about Monson. Sorry.
Judge, I cannot find it in the emails either. Dr. Galasnik, is there any way that you can email me your most recent CV right now? Do you have it available?
Let me see. Uh,
Yeah, until we get a court reporter, I don't think it's a requirement for the hearing, but
No, it's beneficial, Judge, to see
it's
the history.
helpful for everybody.
certainly. Email wise, I've got Frank's and Maya's, but where do you want me to send it to?
Send it to Frank, please.
Frank, okay.
And I will forward it immediately.
Yes, to Mr. McCarthy and myself, that would be most helpful.
And I'm glad Dr. Galasnik is actually sending it, Judge, because he had an update on his CV from the last time that he testified. So,
all right. So I have a quick question. Can you guys hear the background noise over here? Because if it, just let me know because you don't hear anything.
I do not, Judge.
Okay. Yeah, once in a while there'll be sirens because I'm in Upper Manhattan, but it's off of Broadway, but it's a main thoroughfare, so I'll try to mute myself. If you see me muting, it's because there's some kind of background noise. I don't want it to disrupt our hearing.
Okay. I've got to find it here somewhere. Just a minute.
Well, it's all right, Doctor. We're still waiting on the court reporter too. So
Oh, okay. Yeah.
don't feel like everybody's staring at you or anything. Yeah, we still can't go anywhere without the court reporter.
Good.
Trying to find it on my here it is.
I understand.
Okay. I have a notice here saying low system resources may affect your audio quality. So
On me?
I'll just, that was just, and I had noticed I had heard some static, but
Okay. I may have been
see.
bumping on something.
Yes.
yeah, maybe if I can, maybe I need to get out of some programs. I don't think I'm in any particular, but maybe I close.
I believe I
Close
just
some of
sent
your
it.
windows, Mr. McCarthy.
Yeah, okay.
I just sent it. It says it went.
Okay, terrific. Thank you. We appreciate it. As soon as I get it, I'll open it up.
I just sent it to you, Mr. McCarthy, and to you, Judge Rodriguez.
Okay, I just got it. Thank you.
Judge, this is Robert. They just notified me she should be logging on soon.
Okay, thank you.
All systems, I still have all systems.
Hello. Can you hear me, Judge?
Yes.
Okay.
Here, Judge. Oh, see.
All right, I've got it open. Ms. Wright, just let us know when you're ready.
Thank you. I have a little system overload, but I think it'll be okay.
Ready,
I'm
ma'am.
sorry.
Okay, thank
It's
you.
it's almost opening.
Okay, I'm just gonna call the case and ask for announcement of council. You're still trying to open up that?
Yes, ma'am. The document.
Okay.
I did get a notice that my systems are low. I don't really know what that means, and I'm not going to bring a technician in right now.
No, I got the same notice. I just clicked on it and it disappeared. I got the exact same notice. So it may be something from Zoom or I don't know.
Thank you. It's good to know that.
Yeah, I got the exact same notice. Are you able to open it, Mr. McCarthy?
Yes, I have it open. I guess, yeah, well, it's my fault. Anyway, I should have checked on this and talked to Mr. Shelley, but yes,
Just as long as you've got access to it.
hopefully I can switch between our hearing and looking at this. It'll be fine. Thank you,
Okay.
Judge.
You're welcome. The court calls cause number 2020 0D06504 State versus Rodriguez. May I have an announcement of counsel, please?
Donald McCarthy for the state.
Thank you.
Your Honor, Josh Avila, Myrna Pages, and Frank Shelley for the defense. We're ready.
Okay, and we have Dr. Golaznik is going to be the only witness this afternoon, is my understanding. Is that correct?
That's correct, Your Honor.
Okay, Dr. Golaznik, if I may ask you to raise your right hand and you solemnly swear or affirm that the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Okay, you may proceed.
Thank you, Your Honor. Good afternoon, Dr. Golaznik. Can you please introduce yourself to the court and state your full name and occupation, please?
My name is John Gilbert Golaznik, Galaznik, and I'm a pediatrician.
And Dr. Golaznik, can you tell us a little bit about your educational background?
Yes, I graduated from the University of Texas in Austin in 1970 with a degree in zoology. I then attended medical school at the University of Texas Medical Branch from 1970 through 1974. The last year of my medical school was entirely pediatrics. I then did a straight pediatric residency at the University of Utah in Salt Lake City from 1974 through 1977. And at that point in time, to become board certified, we took part one of the board certification exam during our residency, which I took and passed. And then we were required to practice pediatrics for 2 years before taking part two of our board certification exam. So in 1977, I volunteered for service in the United States Air Force. And from 1977 through 1980, I was one of the two board certified, pediatricians at Ramstein Air Force Base in Germany, busy outpatient immunization giving, diaper changing, pediatric practice. In 1979, I took and passed part two of my board certification exams, so I am board certified in pediatrics. The new guys, the young folk have to recertify every so often, but we old folks are grandfathered in. So I am board certified in pediatrics.
When have you been certified in pediatrics? Board certified in pediatrics? Since when?
1979 was when I took the part two.
Are
And
you
it's still current.
are you licensed to practice
I'm
currently?
licensed to practice in Alabama.
Can you, and I know you went a little bit into this, but can you tell us a little bit about your work experience once you became board certified in pediatrics?
Yes, I had always wanted to do college student health, which is high-end pediatrics, the older age crowd. So on finishing my tenure with the Air Force, I took a job at the University of Alabama in Tuscaloosa, and taking care of college students, primary care, hands-on, on-site lab and X-ray, sewing up lacerations, all the kind of usual stuff you would expect in an active college crowd. Then I did that full time through the end of 2001. At that point in time, I had become interested in issues surrounding physical injury of infants and small children after I had jury duty on a capital murder case involving the death of a child. And so in 2001, I retired from full-time employment at the university, continuing to work there on a part-time contractual basis through the end of 2017. But that allowed me to free up time to develop an interest in the area of physical injury of infants and small children. I did that by attending meetings, interacting with colleagues, started to review cases. I was able to go into do research in a biomechanical laboratory, and then I got into consulting and ultimately testifying in cases of alleged physical injury of infants and small children. I have no interest in sexual abuse cases or neglect cases. It's simply the generally infants under a year of age or possibly up to 2 years of age with allegations of physical injury.
That time after you retired, Dr. Golaznik, were you seeing or treating any patients in the clinic?
No, since I've finished my hands-on touching patients at the end of 2017, last time I was actually a treater of very small infants was way back in 1980. My interest in this area comes from research, publication, following the development of the literature closely, And over the years, I've reviewed hundreds of cases of involving these kind of allegations.
Glasnick, so since 1980s, which was the last time that you were the primary treating physician for an infant and a small child, what was your primary focus of your clinical career?
Well, my climate was college student health. That's the 18 to 21 year olds. We consider that high in pediatrics. You might think they're adults, but the problems are much more pediatric related than we didn't treat diabetes and hypertension, stuff like that. It was all lacerations, bruises, and bumps, taking x-rays. Everywhere I've ever practiced, we had on-site lab and x-ray. So every time we took an x-ray, we would look at it with the student and the patient and wait for the it
So
would be overread by a radiologist.
when you were focusing on college student health, there was an on-site X-ray in the laboratory, correct?
Oh, correct. And the same is true when I was in the military. And you had to look at your films or they wouldn't look at them after you.
Perfect. Can you, Dr. Glasnick, I know you touched a little bit upon this, but can you tell the court a little bit about your background on the area of physical injury of infants and small children?
Yes, in 1999, I had jury duty on a capital murder case involving the death of a child. After that experience, I thought it was an area that interested me and I might have something to offer. So by 2001, I had 25 years of service credit with the teacher retirement system in Alabama, allowing me to retire from full-time employment and start drawing retirement income to support myself as I cultivated an interest in this area. And like I said, I started by reading and attending meetings, consulting with colleagues and from around the world. And then by, I guess, the 2004, 2003, 2004, 2005, I was reviewing cases and consulting on cases and testifying in cases of physical injury of infants and small children. I was also, along about 2011, able to go into a biomechanical laboratory and participate in experiments looking at the abusive shaking mechanism of injury and in that area. I have published in the peer-reviewed literature, and I have also actively participated in what's called post-publication peer review, with a number of publications listed on my CV in that area as well.
Before we go into these peer review articles, let's talk a little bit about your laboratory experience. You were talking about how you were involved in a biomechanical laboratory. Did this involve some experimentations or some experiments that you observed?
Oh yes, we went into the with several colleagues. We had a dummy, a model. We could hold, we could shake, we could see what it felt like in our hands, and then we also were reporting on Dr. Lloyd's collection of actual data from his 7-month-old son in terms of the levels of rotational acceleration that could be generated, that the infant was spontaneously generating without injury. And that led to the publication of that article in 2011.
Throughout your career, Dr. Glasnick, have you been consulted on cases involving the physical abuse of infants and small children?
Yes, I've consulted on many cases. I've stopped counting after 400 or 500. I've testified more than 150 times. I stopped counting in that area as well. And I've given expert testimony in 33 states, including Texas, Canada, and New Zealand. And I've also reviewed a number of cases for the U.S. military. And I've testified in Stuttgart, Germany, Kaiserslautern, Germany, Fort Hood, Texas, and Fort Lewis, Washington on military cases.
Dr. Glasnick, insofar as the field of physical abuse of infants and small children, have you published anything in this area yourself?
Yes, I have. I'm author or co-author on 3 articles relevant to the issues that are frequently present in these cases, and one had to do with the choking event, cessation of breathing. One was the activities of daily living, the Jumperoo study of with Dr. Lloyd and Dr. Willie and Dr. Lee. and the other one had to do with a in utero etiology of the chronic subdural collections and effusions of infancy, a case that had clear evidence of that having arisen before birth, not as from trauma, but as forming while the baby was still inside the uterus.
And Dr. Glasnick, were these articles that you published, were they peer reviewed?
Yes.
Can you explain to the court what we mean by peer reviewed?
Peer review means that you write an article. It doesn't mean it automatically is published. You send it to a reputable journal. They will take that article and look across the field of people who they have identified who might have expertise in evaluating the quality of that article. And then they will ask them to review it and offer feedback. They can say, oh, it's a great article, publish it. We'd like some more clarification, or we don't think it should be published. And if at the end of that discussion it is felt that it should be published by the editor, it is then published. That does not end the process. Once it is published, it then becomes open to the general medical community to respond to. That's called post-publication peer review or letters to the editors. These are not automatically published either. You write them up, you submit them to the editor commenting on an article. They will then coordinate that comment with the authors of the article, and after an interchange, if the post-publication review is felt to be worthy of publication and forwarding discussion on the topic at hand, it is then published. So on my CV, you'll see some the ones that are peer reviewed, and then you'll have what's called post-publication peer review. I think it's along about page 4. I have a number of those, generally focusing on things like retinal hemorrhaging, the abusive shaking mechanism, shortfalls, chronic subdurals, and cortical vein thrombosis type of issues, which are common in these kind of cases.
Subject matters that you yourself have published, peer reviewed, as well as post-publication peer reviewed, these all relate to the analysis of abusive head trauma, correct, on children?
Yes, mechanical trauma, impact, lead shaking, or medical causes which could mimic those conditions, those presentations on infants and like I said, small children. I don't look at sexual abuse. I don't look at neglect issues. Most of what a full-time child abuse pediatrician does has to do with those kind of issues. There's only about 1,000 cases a year in this country that I would be specifically interested in, and so that's what I do. I'm not a board certified child abuse pediatrician. In 2009, that subspecialty was created. But again, since I'm an old folk and I have no interest in 95% of what those people have to deal with, then I am a board certified pediatrician who's taken interest in this area.
Lesnick, insofar as, peer reviewing, post-publication, and perhaps you yourself making some research, have you yourself have done any research or peer reviewed anything in regards to the biomechanics of shortfalls?
Well, I've followed it closely. I have the literature. It comes through the pediatric literature. It's not all in the biomechanical world, and so that I've not participated, specifically in the shortfall, but I've certainly talked about, published about, commented in my publication, and I've testified about shortfalls in numerous cases because it's common in these cases.
And Dr. Galassi, excuse my ignorance, but when we're talking about shortfalls, what are we talking about?
Well, I think that usually any head drop of less than up to 3 to 4 feet, and now even now down to 24, 28, 30 inches, the damage that can occur with those kind of shortfalls.
And and you have read literature insofar as when it comes to shortfalls where it supports abusive head trauma and where it doesn't, correct?
I've read the literature on the research into shortfalls, the levels of force that can be inflicted and the results of that, and how it interacts with the allegation of abusive head trauma. I would comment that the term abusive head trauma is fairly nonspecific as to mechanism. And so that there's, if you're going to be talking about mechanical trauma in an abusive situation, you're either going to be alleging abusive shaking or impact. And so that, and the shortfall events are common. None of this is common, but of the kind of cases like this coming forward, shortfall events are at the basis of about half of them.
Dr. Glasnick, you touched briefly on this, but just to kind of conclude your experience in this area, have you yourself presented on subjects relevant to the physical injury of infants and small children?
Yes, I've presented on the what stops breathing, the choking algae. I presented several times on retinal hemorrhaging, and I have twice. Well, just last fall, I gave a continuing legal education presentation to the defense attorneys in Oklahoma.
Dr. Glasnick, let's switch gears briefly. You are here testifying as a pediatrician. When a pediatrician, in terms of the treatment of child injury or child trauma or physical injury of an infant or a small child, what is the role of a pediatrician compared to, let's say, perhaps a radiologist or a pathologist?
Well, the radiologist is a consultant, as is the pathologist. They're not writing orders. The child abuse doctor is also a consultant, not writing orders in the chart. They make recommendations or they interpret studies that are ordered by the treating physician who is in charge of caring for that patient. So that the pediatrician's role is to then in addition to kind of ordering the treatment of the patient in front of them, is to then be ordering the imaging studies, ordering the laboratory, and then when the results come back, to try to piece the whole puzzle together. Now, in some of these cases, of course, if the child is desperately ill and dying, the care it will fall to the intensive care doctor or to the neurosurgeon. I'm not a neurosurgeon. I'm not a pediatric intensivist, but the pediatrician's role is to pull the various input together, coming from all the various consultants to try to form an opinion or make an interpretation.
Just to be clear, because I know you like to make this distinction, you are not here to testify insofar as being a radiologist, a pathologist, a neurosurgeon, or an ophthalmologist, correct?
That's correct. Everyone looks at, you start by looking at the films in these kind of cases, and then you look at the way the radiologist interpreted the film. And if I totally agree that what I'm seeing matches exactly what he said, I'm very happy with that. If I see something that I don't think has been addressed or have questions about, I would then be recommending to the defense attorney to approach a radiologist for a review. So I do frequently present imaging, talk about imaging, but I'm frequently, particularly like in this case, I have no problem at all with the radiologist reading in the chart, and what I would want them to actually be testifying as well.
So I do want to clarify, as a treating pediatrician, even though you yourself are not a radiologist, you can review and you have reviewed radio, imaging, like imaging studies like X-rays, correct?
Oh yes, that's the first thing you start with. You look at the imaging and you go to the initial history of how the baby comes through the door, and then you go to the medical records to see what matches and what unfolds from there.
What other imaging studies are you able to review and observe as a treating pediatrician?
Well, ones I specifically am interested in are the plain X-rays, chest X-rays, skeletal survey, the bone imaging, and again, that's something I've looked at throughout my whole medical career, college, military, and then see the CT scans and the and the MRIs. I also have colleagues from around the world who I have access to consult with, review with, and learning under their guidance, learning on the job about the significance of these studies.
No, I'm glad that you touched on this area, Dr. Galasnik. I mean, do you yourself as a pediatrician consult with different kinds of branches in your involvement in the specific area of issues surrounding physical injury of infants and small children?
Oh yes, I have almost daily contact with forensic pathologists, pediatric neurologists, neurosurgeons, and pediatric radiologists, as well as biomechanical engineers. In my involvement in these cases, we will inform each other, talk to each other, interact, and that's very standard. I mean, the American Academy of Pediatrics for the child abuse doctor recommends that they are coordinating with the specialist in their hospital as well, from the orthopedist to the radiologist to the neurosurgeons.
And just to be clear, and I do want to talk a little bit about how you consult. You don't consult, especially when you're involved in cases, you don't consult with the actual radiologist, neurologist involved in the case, correct?
Correct. I receive the records and the imaging through the attorney, and then I come at the cases looking at the objective records in the chart. It would actually be I hate to say it's not but it's almost never offered to actually talk to the radiologist at El Paso or the radiologist somewhere else. That could be viewed almost as witness tampering or something else if I was to try to influence what they were saying. So, or if I were to just call them up on the phone and say, I'm looking at this case, can we talk about it? That would be a HIPAA violation if they talk to me.
Thank you, Dr. Galasnik. I do want to harp back on a point you talked about previously, which is you have previously testified as an expert in trial proceedings, correct?
Oh, hundreds of times.
And and I don't want you to list them all, but where have you, how many states have you been qualified as an expert in trial proceedings?
33 states
Mhm.
in Canada, New Zealand, and then for the U.S. military, testifying in Europe, Texas, and Washington State.
Is there any specific example of your recent involvement in trial proceedings in Texas?
Yes, I testified in McKinney, Texas this year. I also I was to testify in Corsicana. The judge didn't allow that, but we were going to appeal her exclusion in that case. But the jury came back with a not guilty verdict, so we couldn't appeal it.
And then, and anything else in regards to an appeal in Texas?
Yes, I was part of the effort to get on the Rourke decision, which recently came down in October of this year, of the overturning of a conviction, and I testified in that and was cited repeatedly in the appellate court's decision.
So,
Melissa O'Rourke.
O'Rourke.
Yes.
And just just for the record, and so the court knows, Judge,
I'm completely familiar with the facts of that case.
but this ruling recently came out. It came out on mid-October of 2024. It still doesn't have a reporting number, but I do want to state for the record the docket number. It's docket number WR 56, 380-03. And you were involved in that case, correct, Dr. Galasnik?
Yes.
And it was, I don't know if you know this terminology, but it was an 1107-3 writ on that case, correct?
I'll take your word for it. You're right.
Okay,
I'm not familiar with the terminology.
It's out of Waco, Texas. I'm familiar with it.
Okay, perfect. 1 second, Your Honor.
I mean, it's nationally known, obviously.
Your Honor, thank you, Dr. Galasnik. At this point, I have nothing further, unless the court wants to hear arguments. I do pass the witness.
Mr. McCarthy. Hold on. Mr. McCarthy,
You're muted, Mr. McCarthy.
you're muted. There you are. No.
I'm sorry, Mr. Counsel finished sooner than I thought. I think for everybody's benefit, I will be asking the witness a little bit about the Rarick case, however you pronounce it. So
Would you spell it, please?
it sounds like you're very familiar. Does anybody need
Can I
me?
spell it, Judge, please?
Hold on, Mr. McCarthy, the
Sorry.
court reporter would like it to be spelled. I was just going to print the case out.
Yeah, I was just going to send it to everybody. But I don't know, if anybody even needs it, or even the witness, or if he just knows it. But I mean, I got it ready to send. But as far as its style and so forth, yes, I can repeat that, Your Honor. Give me a moment. For the court reporter, I hope you can hear me because I'm having trouble hearing people because of my systems. But for the court reporter, the case is ex parte Roark, ROARK. It's 2024 WL 446858. Repeat, 2024 WL 4446858. I think that should be a sufficient reference for the record. And Judge has already commented that she knows the case well. The witness, I mean, in other words, I can send it obviously through Westlaw immediately to anybody.
I have Westlaw open. So I have the case in front.
Okay. Okay, I'm back. I thought I was. Okay. Sir, I do want to talk about Rarick and a little bit more about your background and your thinking, but let me get one thing out of the way. This is not going to be I hope terribly adversarial, but let's just start with this expert witness and being qualified or not qualified a number of times and so on. You said hundreds of times, I think you said hundreds of times you've testified in cases, in like legal cases and trials. Is that what you meant? Hundreds of times?
Yeah, I stopped counting some years back after 150 times, and sometimes I'll testify multiple times in the same case. I mean, in this case, is this a testimony or is this a case? Will I testify more than one time?
Yeah.
I don't track that. It's just it's cumbersome, and I just have not tracked them all, but it's certainly well over probably 150, 200 times at this point.
Okay. And the cases, all of them are in this general realm dealing with accusations or controversies having to do with injuries to small children, babies, and whatever the field should be called, because I mean, it's not just shaken baby syndrome, is it? There's other things.
Oh, right. It's physical injury of infants and small children is generally going to involve either impact, allegations of shaking, or medical diseases or presentations that can have similar presentations. probably 90% plus of the cases I look at are going to be infants less than a year of age. Once the 1 to 2-year-old age crowd is going to be possible, they can toddle and fall, type of things. They're way too big to even suggest shaking on, and then multiple fracture cases where the child comes in with multiple fracturing, and the question there is whether they have metabolically weak bones versus some kind of abusive forces applied to the child.
Okay. Okay, so let me, I mean, I'm impressed with the foreign work and all that, of course, but so we get it down to US and Texas law and stuff. And just so we get maybe a ballpark, I mean, I think it's obviously relevant if you've been qualified other places, but let's say just in the realm of Texas state trials, or federal trials in Texas, can you give me a ballpark estimate of how many times you've been qualified?
I would think at least 10 or 12. East Texas, Lubbock, Houston, Corpus Christi, multiple times in Dallas. Um, um, uh, yeah, I think at least 10 or 12.
How many times have you been prohibited or not qualified, or judges decided not to let you testify?
I've been blocked from testifying 4 times, once in New Orleans, twice in Tennessee, and of course this last time in Texas, where we were going to appeal that exclusion, but a not guilty verdict made that irrelevant.
If you recall, what was the judge's basis? And that was Corsicana, right? You said?
Corsicana. I don't remember his basis. I just think he decided that he just was not going to let me testify. And previously I testified in McKinney, Texas, which is, I guess, about 60, 80 miles north, about 2 months before, as a sole witness. And I think we got a not guilty verdict. So I was a little surprised at the Corsicana judge's position.
Now, do you recall the situation in State v. Riddell,
That's out of Louisiana, right?
in Louisiana well, I guess almost 2 years ago?
Yes.
Okay. Can you tell the carts what happened there? What the judge's reason was for?
I didn't really follow the reasoning. He thought that I had overstated my conclusions and was, I guess, too definitive. So he blocked me. I handed my exhibits to the next witness, and he presented basically my case.
Okay. Do you recall the judge determining that you were going to try, quote, to act as a 13th juror?
That's the term. I don't know what that really means, but that's what he said. I review a case and I come down to the end and say, in my opinion, to reasonable certainty that this is what applied, but somehow I don't know what he legally objected to my conclusion. So I now, I guess, soften my wording a little bit, but that's all I remember. I was kind of confused of what his objection was.
Okay. Did you recall him saying that your expertise was unclear?
I don't remember that term.
Do you recall him saying that I heard him making a legal conclusion?
I think he said that, and a legal conclusion is if I were to say that, in my opinion, the evidence does not support the allegation, is that a legal conclusion? I don't know what exactly the wording that he objected to, and it was conducted outside the jury, so the jury never heard me. So I don't know what his feeling was.
Okay. And this will relate in some sense to the Rarick case. The judge said that that you would suggest that any reasonable hypothesis, whether evidence or not, whether there was evidence or not for it, any other reasonable hypothesis should be considered by the jury, irrespective of whether any evidence was put on for such a hypothesis.
I don't remember saying that. That testimony there was, I think, was almost 7, 8 years ago. I don't remember saying that. I do think that my role, is to review a case and look for potential mimics, and the burden placed on the accuser in these cases is to rule out all plausible alternatives, so that my role is frequently to assess what's there, form a differential like is standard in medicine, and then to assess whether the accusing physicians have actually met their burden of ruling out all plausible alternatives. That wording comes from 2018 of the word plausible. But that's my approach to these cases, and I routinely testify that how do I approach a case? I generally start with the objective data, the allegation that comes forth, and I match the allegation with the objective data, imaging, laboratory, with the relevant current literature that I'm aware of, to see if I can get from point A to point B through the history as offered with a non-abusive pathway. Then I start with the same basis, taking the prosecution's allegation as to how the injury was inflicted, and then try to match that against the objective findings coupled with the current literature to see if that can also get me to the same endpoint. If it does, I say it may be consistent with both, and there's nothing medical is going to make a distinction. If the allegation does not match, in my opinion, the physical findings and the objective data, then I have to say that I don't see that the allegation is supported.
And that it's actually your opinion, or you hold the position that where a shortfall theory of defense is offered, that where a shortfall theory is offered as a defense, doctors should not be allowed to testify their opinion that the situation represents an abusive injury?
I don't remember. That's not my opinion. My opinion is that certainly with the publication of the Atkinson's 2018 of witness shortfalls by the child abuse doctors themselves, that a shortfall, a drop of as little as 28 to 30 inches can account for all the findings in this case. Yes, it's rare, but for them to say that a shortfall could not account for the findings, given that the child abuse doctors themselves published this case series in 2018 of 8 witness shortfalls, all with subdural bleeding, all with retinal hemorrhaging. One required emergent surgery and one died. And those head drops, the one that died, was simply pushed over from a standing position, a head drop of only 30 inches. Yes, it's horribly rare. It doesn't happen all the time. Kids fall all the time. But to come into court and say that a history of a short fall could not account for subdural bleeding, retinal hemorrhaging, and various degrees of brain injury, my position is that would be inconsistent with the current state of the literature.
Oh, quickly, what was the inch range again? I know you said it.
Oh, in the Atkinson's article, these were toddlers, about 30 inches tall, and several of that in that witness case series, they were standing with their feet on the ground and fell over, hitting their head on the floor or on a hard surface when they fell. So that's where I would get that 28 to 30 inch drop as out of the Atkinson's article. I think I've provided it to the defense if you need a copy of it or don't have a copy of it. And the biomechanical research, when you coordinate the infant airbag studies, car wreck airbag studies with the biomechanical reconstructions, you also come up with the same kind of numbers at about 28 to 30 inches. The potential for skull fracturing is clearly recognized now to be down as little as 24 inches to a hard surface is adequate to cause skull fracturing on an infant.
Okay, so that's, if I understood you, you're talking in this instance, or in these examples, when you use 30 as a top range, it is, as it were, head to head, upside down because you fell. Is that?
No,
You're standing. Go ahead.
The Atkinson's article, one of the kids was standing in a basket on the floor and fell over. The other kid was at a family gathering and was pushed over by another kid. A toddler standing fell backwards and hit his head on the pavement and died. That is horribly frightening. Exquisitely rare, but if it happens at a family gathering before people, it cannot be denied. So that at least the potential for a short fall of those kind of distances to do devastating damage, I think now has to be recognized. And again, kids fall all the time. We're not talking about holding up and dropping head first. We're talking about standing feet on the ground and falling over.
Okay. So this is a technical question right now, in the sense, I'm trying to understand the 30 inches and all that. The basket, for example, that situation and the tragedy. Okay, so standing, you fall over, and you're right. Of course, we don't fall upside down.
Right.
So, is it really 30 inches, or is it less?
Well,
I just want to get it.
All I can say is I go to a growth chart of a 18 to 20 month old, and his head's about, top of his head's about 30, maybe top, maybe up to 32 above, and he is then falling over and hits the surface, so that is about a 30-inch head drop.
Okay. So based on going back to things you were saying a little earlier, talking about what happened in Riddell and all, and what you think your role is, you think your role is to grade the quality of the physician's work?
My role, let me say it this way. My role is not to come in and say this is not abuse. I think you can have abuse with a normal physical exam. You can have a rape with a normal physical exam. A defense expert is, I don't think, ever going to be able to say that a situation is absolutely not abuse. My role is to see if alternative, or if the accidental event or medical problems plus an accidental event or medical problems alone can also account for the findings in this case. So from that respect, since the duty, the burden that the child abuse doctor has undertaken themselves is to not make the diagnosis of abusive head trauma until all plausible alternatives have been ruled out. and we're frequently looking at the same list of differentials, is to then assess whether, on my review, the child abuse physician has actually ruled out all plausible alternative explanations, and then if not, then I think those plausible alternatives need to come to court so the jury can decide.
Having said that, I just heard you. Then would you not agree that your opinion is that every conceivable, reasonable hypothesis, even though there was no evidence for it presented?
I don't think that's true. That's not what I said. I said I start with the
No,
history
see,
that
no,
comes
I
in the
don't
chart.
know. No, I'm sorry. I don't know what your question is. Yeah, I have the reasonable hypothesis, even though there's no evidence for it, and you get cut off. So whoever.
I start with the history in the chart and the objective findings, almost always the imaging. So I'm starting with that. I'm not saying that a meteor flew out of the sky and hit somebody in the head. I'm saying that is what needs to be matched with the objective laboratory findings in the record with the current literature to see if an alternative explanation applies. That doesn't, I don't know where or how what you're saying you thought I said came forth, and there may be, but my testimony is much like I said. How, Dr. Glosnick, how do you approach a case? I start with the history that comes through the record. I don't interview people. I don't go out and talk to the neighbor. That's not my job. But the history that hits the record, I then match it against the imaging and the reports on the imaging from the radiologist, particularly in the case at hand, and the other findings, and then the course through the hospital and then match it with the available literature. And if the history that's offered, coupled with the imaging and the course through the hospital, can get me from point A to point B to explain all the findings, then my position is that this is consistent with a plausible alternative explanation. Now, again, that's what I have interpreted as my standard approach as I try to get that across when I testify.
Okay. Your Honor, may I clarify with the court reporter, because I thought she may have made a comment that my question was not heard.
Before we do that, I just want to remind everybody, the attorneys and the witness, that we can't talk over each other and we can't interrupt each other. Everybody's got to finish, because a court reporter cannot take down a question and the answer at the same time. So I'm just going to remind you all of that. But
sorry.
No problem.
Yes, ma'am. I actually thought she said that I had broken up, but she's on mute. So
no. Ms. Wright, have you been able to hear everything?
Yes, ma'am. I was able to hear everything. It was just the interruption, and then he just proceeded to answer the question, whenever he heard it.
I apologize.
well, that happens. Okay, thank you.
Thank you.
Sorry.
We appreciate that.
So based on what you just said, I know you've testified many times, but sir, I'm sorry for hesitating, because I certainly don't want to act condescending. You're a very intelligent man. But sir, you know that in a trial, the jury must hear facts or allege facts, the presentation of facts, assertions of facts, and must base its judgment on that in combination with instructions that it's given by the judge. jury
I'll
instructions
object.
combined with facts.
Oh, hold on,
You understand that?
hold on, Mr. McCarthy, there was an objection. Yes.
Your Honor, I object to relevance, compound question. This is outside the scope of this motion, Your Honor.
Okay, I don't know about.
Hold on,
Yes,
Mr.
yes, ma'am.
Mr. McCarthy, I haven't heard the full question, so I haven't heard it all, so I can't rule on the objection. What is the question?
Yes, ma'am. If it was compound, I'll try to correct that. Do you understand that the jury's job is to decide a case based on facts presented or alleged facts combined with instructions from the trial judge?
I
Dr.
understand that.
Dr. Galasnik, yes.
Hold on.
Yes, ma'am.
Mr.
Okay,
Avila's
I'm
going to make an objection. Okay, your objection, Mr. Avila.
Judge, I would object to relevance. I still think there's a compound question in there, as well as this is clearly outside the scope of this hearing. I mean, if he wants to address this on cross-examination at trial, I think that's fine, but this is calling for a legal conclusion that is not on Dr. Galasnik's hands, especially given the scope of this hearing.
I'm gonna give him a little bit of leeway, and I'm gonna overrule. I think I don't know what you're trying to get at, Mr. McCarthy, but I'll give you maybe one or two other questions because I don't know where we're going.
Want me to try to answer?
Yes, you may
Yes,
answer.
sir, if you remember the question.
Okay. I think as I heard the question, I think a point I would like to make is that the American Academy of Pediatrics defines my role in these kind of cases also as bringing the relevant science to the courtroom, so that apart from necessarily that the jury as a trier of fact needs to have at their hands what is the research is, what are the potential forces in play, the potential for a shortfall to cause injury, and what does the research into that injury show? What is the research that's available into the potential for skull fracturing with head impact? What's the thickness of an infant skull? What kind of impacts can cause a skull to fracture? If the jury does not hear that kind of published peer-reviewed science, then they are not in a position, I don't think, to make a judgment simply based on the two things that would seem to be embodied in your question. So my role, like I said, was to look at the objective findings, the history that comes with the chart, and the imaging, and then match it against what the relevant literature says. Like in terms of skull fracturing, clearly with pediatricians' names on it, the research is saying a shortfall impact of as little as 24 inches can result in skull fracturing, that the infant skull is eggshell thin, and the jury needs to understand that. So that the force to break an infant rib has been studied, and the jury needs to hear what force it takes, it has been demonstrated to potentially break an infant rib. So that is my role, is to try to make sure the trier of fact hears that kind of evidence, and that is that, so that and that, I guess, is incorporated into the jury instruction. But I guess that's the best way I can answer. I don't know if that answers your question or not.
You understand that you cannot create facts.
Oh, I
Correct.
understand that. I say I try to.
It's argumentative.
An overrule.
Your Honor,
Yes.
Just the court reporter, we need to switch out court reporters.
Okay.
Just may have just a few
Everybody
minutes.
just cool your heels for a minute, and we'll do that. Thank you so much. We appreciate it.
Hi, Judge.
Hey, how are you? You want me to go ahead and give you the class number?
Is it 2020-0D06504?
Yes.
Okay, let me just figure out who's on here real quick.
All right, we are in the middle of a testimony from Dr. John Galasnik, Galadnik. And this is Judge Yvonne Rodriguez. The state is represented by Donald McCarthy, and the defendant is represented by Mr. Joshua Avila and Ms. Mirna Pages, and Mr. Frank Shelley. And everybody's name is on their Zoom.
Yes, just give me a quick second to,
Yeah, no, I understand.
thank you. Thank Shelley, and then who else was for the,
Mirna Pages
okay,
and Joshua Avila.
who is the one currently questioning next?
Right now, Mr. McCarthy is questioning Dr. Galasnik.
Okay, and then I believe,
You want the style of the case?
I believe I have it here. It's State of Texas versus Arit Rodriguez.
That's correct.
Just give me 1 second to identify my speakers and then we can get started.
No problem. Just let us know.
Okay. Whenever you're ready, Judge.
Okay. I think, Mr. McCarthy, you were getting ready to ask your next question.
I was, and I think I asked it, is it readily available to the court reporter? I mean, is it right there? My last question.
No.
Okay.
Because we changed court reporters. So the
Oh, they don't have,
reporter, yeah, no, it's a different court reporter now. So she doesn't have what you said.
oh, okay. With your honor's permission, then procedurally or technically, were I to need a transcript of this hearing, I'd actually would have to contact both court reporters. Is that
That's correct. That is correct.
Thank you. Okay. All right, sir, I believe my last question, see if you agree, was that that you understand that you cannot create facts as a testifying expert.
I agree. I understand that. I'm not sure I understand an example of what kind of thing you're referring to when you say create facts. If I start with imaging, I start with research, I start with laboratory tests and physical findings. Those are the facts of the case. I don't know where I guess I'm confused about when you say create facts. I don't know how to interpret that.
When you say that, and you tell the jury that the jury should consider some innumerable number of alternative hypotheses, are you not presenting facts that are not in evidence?
I don't know when I say that or how it was interpreted as that. Like I say, I start with the history. So I'm not starting with making up history. I'm starting with the objective data, the imaging, the interpretation of imaging, the laboratory, and I'm starting with the literature. I don't know where in that you're getting to the idea of making up facts that confuses me, and I don't know how to answer that question in those kind of terms.
Okay, you've been qualified as an expert witness many times. Do you understand your role to comment honestly on, I'm going to be called compound questioning here. Sir, I'm going to back up. In the context of a criminal case, do you agree that your role as an expert witness would be to help the jury understand a theory of defense that has had some factual foundation in evidence already?
I think the answer to that is yes. My role is to bring the science relevant to the allegation of how the abuse was inflicted and the literature that supports or challenges that. And then in every report or whatever I'm ultimately asked to write, they always want me to sum up my opinion. In my opinion, is this, consistent with, and people seem to like the term within a reasonable degree of medical certainty, is what I see in the child abuse reports, are type of wording, so that I don't know where you're going with that. If I feel that if I take the allegation and it clearly does not match the facts of the imaging, the interpretation of the imaging read by the radiologist, then I have to, I think in my conclusion should say that in my opinion, the facts don't match the allegation, and therefore the allegation is not supported. But that's I think my statements from the stand are frequently that's how I frame it. I don't know how to what you're getting at beyond that.
Do you recall on direct exam, an hour ago or more, maybe, you testified that you have not participated in the shortfall research. Was that, do I have that correct?
I think so, but let me tell you what I meant by that. Okay, is that the biomechanical research into shortfalls is they build these very expensive dummies and they drop them from 1 feet, 2 feet to 3 feet, and they record the forces in play at that, and they publish that. That research is engaged in by biomechanical engineers, usually coordinated with pediatricians and neurosurgeons, and then they publish that research. Now, I have not been in the lab when that research was done, but when it gets published in the literature for pediatricians to interpret and to deal with and to take into account, that is where that stands. Now, in terms of the shaking allegation, I went into the lab, I built models myself, I have held a model, I've attempted to shake it, I've attempted to reproduce the Corey shake, and then we published that type of stuff. But that is how I have engaged in that kind of research. But again, the same question would go to any intensivist or any child abuse doctor. Have they gone into the laboratory and built the models and done the experiments? Carol Jenny built the models that I'm frequently citing. She's a child abuse doctor. She has done it, but these tests are very expensive. They hundreds of $1,000s of grant money go into each one of them. So very few doctors will actually be in the room when it's done. But when that research is published, it is published to be used and applied two cases. And so that's how I answer that.
So you're not here to testify as an expert in shortfall. Is that correct?
I am here to bring science to the courtroom relevant of the shortfall research, which is in the literature, published, peer-reviewed, reproducible, that serves as the basis for so the jury can make an intelligent position. I think I have followed the research as closely as any pediatrician, as closely as any child abuse pediatrician, as it gets published and presented. I testify on it, because if you're going to say the expert is the person, only the person who's stood in the laboratory and done the research, then your handful of people is very, very small. So that whether you want me to say I am not an expert in shortfalls, I say I'm an expert. I'm a board certified pediatrician who has followed the shortfall literature very closely. I think I am very well suited to bring the published science to the courtroom, present the research as it was done, and the results that was published, so that the jury can have that knowledge at their hands when they choose to try to make a decision. Without having that kind of information presented, then the jury is really left in the dark as to what the state of the science actually is.
Okay. And so we're clear, you did just state, that is to say, paragraph or two ago, I am not a shortfall expert.
I am
Correct.
not sure I'm ready. I'm not sure I'm ready to allow you to say that. What I'm trying to say is, what is your definition of a shortfall expert?
What is your definition?
Well, my definition is
I
someone.
withdraw the question.
Your Honor has
withdraw the
to
question.
question and answer, and this question has
withdraw
been
the
asked
question.
and answered. Judge, you're muted, Judge. I apologize.
You're muted.
The screaming sirens. Let's, Ms. McCarthy, when we get an objection, can you just stop speaking? And your objection, Mr. Avila?
Your Honor, I would just ask that we keep it question and answer format, as well as it was asked and answered and it was argumentative.
And I withdrew the question.
Your next question.
I withdrew the question. I withdrew the question, and counsel knew I withdrew the question.
Okay, I didn't hear that either. So I did not hear that. Your next question.
Okay. So sir, so we're clear, because you did at one point say, I am not a shortfall expert. And then just now you adjusted that. So what do you want to say on that question?
I want to say that I have followed the literature from Clinich 2002 through Prang, through Coates, through Margulies, through Atkinson's 2018, and I have followed that literature very closely. I presented it at meetings. I have published articles including that literature. And so I think I am as versed as any pediatrician in terms of presenting that information to the jury. Now, I don't know how I can be more clear than that, but but that is how I define my background, what I bring to the trier of fact in terms of shortfalls, and whether a fall did or didn't occur, that's up to someone to decide. But I think that I am as in a position to bring to the court what is in the published literature as to the potential effects of a 24, 28, 32, 36-inch head drop to a surface. And I am, I think, as versed in that as any other expert that you might bring in.
So are you now saying that you are an expert in shortfall?
I don't know how you
Honor,
are trying
as
to.
I'll object, Your Honor, as to this question has been asked and answered, and that's the relevance at this point.
Your Honor, I think it's highly relevant. We have to make a decision. Well, Your Honor has to.
Absolutely agree, it's relevant, but I think
Judge, I can't hear you. You're going in and out.
apologize.
Okay, I'll try to speak up. I think it's highly relevant. It's an important decision for the court to make, and there's a lack of clarity about what his position is.
I understood his position.
Your Honor, I could not hear you.
Yeah.
Sorry. I don't know what to tell you. Can y'all hear me now? Can you hear me now?
A little bit better, Judge.
Can you hear me better? I'm having the same issue that Mr. McCarthy is that they're telling me that the video, the audio is an issue. So, but it's sustained, and in response to Mr. McCarthy, I sustained it on asked and answered, except if he has answered it, I'm clear.
Are you aware that this court has qualified a shortfall expert in this case?
Is that the
beg
end of
your
your
pardon.
question?
That was the question. Sorry.
Oh, I'm aware that Ken Munson has testified. I know Ken Munson. I have had cases with Ken Munson. I agree he's a biomechanical engineer in these kind of cases. I was unaware of when he had gone into the laboratory and done specifically research in terms of thought he was more into the strength of the bridging veins and this kind of stuff. But I understand that you have a biomechanical engineer on the defense has retained a biomechanical engineer. And I think that the biomechanical engineers is the relevant subspecialty in investigating abusive shaking, shortfalls, skull fracturing, and bone fracturing. They're the ones doing the actual research. But when they publish the research and they publish it with their findings, then it falls to the rest of the medical community to read the research, understand the research, and apply the research, and then bring it the science that's available to the court. That's what the American Academy of Pediatrics says I am to do. So that whether you say that my position in this makes me an expert or a bringer of expertise from the literature to the court, I don't know how to define that further, but I will not abdicate my position to ever discuss and talk about shortfalls in these kind of cases. It's something I do routinely. I have testified in a number of cases on shortfalls. I have testified in post-conviction relief, getting convictions overturned where shortfall was the issue. So that that is, I guess, as far as I can go in answering your question.
Your Honor, I would at this point object as to the misrepresentation on the question. Dr. Munson, I believe Mr. McCarthy was referring to Dr. Munson. He was not qualified as a shortfall expert. He was qualified as a biomechanical science expert with testimony in this case, Judge. So I wanted to clarify the confusion because maybe that may have confused Dr. Galasnik as well. We didn't hear you, Judge. I apologize.
Noted for the record. Noted.
Oh, noted for the record. Got it.
Yeah.
Sir, so I guess, how familiar are you with the CV of Dr. Munson?
I don't think I read it recently.
Okay, would it surprise you to know that he's been published in a number of leading scholarly journals and has done the, I'll stop there and it won't be compound. Are you aware that he's had a number of impressive publications?
Absolutely.
Objection, relevance, and calls for speculation, Your Honor.
Well, no, he knows or he doesn't, so it doesn't call for speculation, and it's highly relevant.
Hold on. Let me just overrule. Did you get that overruled? Overruled.
Yes, we did.
You can answer the question if you remembered it, sir.
I remember, I know Dr. Munson is well published. He's a biomechanical engineer doing this kind of research. This research is usually done in coordination between a biomechanical engineer team and a pediatric medical input. Just like I have participated with the biomechanical experiments with a biomechanical engineer, and or at least he's the British equivalent of that, and published in the area, so that that is what I've done. I've also served as a peer reviewer for the Journal of Forensic Biomechanics, and so that is what I've done, and the court can, I don't know what they want to do with that, but that's who I am.
It's a little minute, but you've been published. So do you agree that in these scholarly journals, the general norm is that with multiple authors, the last name is considered the senior academician, let's say.
That's frequently the case, but sometimes they will list the primary author as first, so that but that order, I have seen it both ways, and usually in an article it will also list as the corresponding author, who is the one to whom you might direct questions if you have them. And I have if you're referring to Dr. Munson, I think he's a superb researcher and a biomechanical engineer. If he were to come in and say that a short fall cannot kill or produce these findings, that would jolt me, given the research that's in the pediatric child abuse literature and biomechanical literature that I'm familiar with.
Is it correct? Well, let me back up. My understanding, and it really is only my understanding, is that you were called by the defense in this very same cause number to testify in an expert capacity. So that's right?
Yes, I'm not here as a treating doctor. That would be the so the two categories I'm familiar with is the treating doctor, the one who actually stood there by the bedside and took the blood and ordered the medicines, and those are the treating doctors. And any other doctor who is brought in to would be serving in the capacity of an expert witness to bring the relevant science or a relevant body of knowledge to the court. That's my understanding.
Okay. And in that instance, in this case, then, feel free to object to my terminology, okay? The factual scientific theory of defense was shortfall.
That's my understanding, is that's the history that came through the chart. was a part was not witnessed actually. And so that is the that comes through the record. So what I then bring to the case is to assess that in terms of the available pediatric published literature and the child abuse literature, starting with that, and then to look at other issues to see from a pediatric perspective what also needs to enter into beyond just a potential impact to the head. So that that's why I when the attorney approaches me, they don't say, "Are you a shortfall expert?" They say, "Can you review the records to see what you see in the records that that might apply to this case?" So that's how I start, and that's what I try to bring. That's my approach, and yeah, that's I guess my answer.
Thank you. So I understand you remain board certified in pediatrics as a pediatric physician. That's correct.
Correct.
Yes. You've also been careful, I think, to point out that you are not you're not an ophthalmologist or a radiologist, or you even said a pediatric intensivist is the word I wrote,
Right.
and nor a surgeon, correct?
Correct.
Therefore, you are not an expert in ophthalmology, correct?
Oh, that's correct. And if I can address the ophthalmology role, if I can, since you started with that, is that the ophthalmologist comes by and looks at the patient and documents what he sees. Perfectly fine with that. I do not do that. But then my role is to take what he says he sees and then match it against what's in the biomechanical literature, what's in the animal research, and what's in the human research that is relevant. The ophthalmologist is not doing that or necessarily doing that. I would want him questioned in court. Has he followed the biomechanical, animal, and human data relevant to retinal findings? And if he has not followed that, then I don't know. He can come to the court and say what he sees when he looks. But the issue is, what does the research say in terms of can certain things result in that finding? And most ophthalmologists that I've encountered have not followed the biomechanical, animal, and human research data relevant to retinal hemorrhaging in these cases, where I've done my best to do that. I have presented it at meetings, and I have written multiple letters to the editors on that kind of thing. And I've even challenged the American Academy of Pediatrics Committee on Child Abuse and Neglect to address the issues that I am raising and presenting to them. So that, no, I'm not an ophthalmologist. I don't pretend to be the guy that looks in the eyes, but I am closely following the research that is relevant to relating the role of retinal hemorrhaging to a case of alleged abusive injury.
Okay. And to answer my question, you've already testified that you are not an ophthalmologist. And my question was, therefore, you are not an expert in ophthalmology. Could you actually answer that, yes or no?
I can't answer that yes or no. What I can answer, I'm not an ophthalmologist. But I have followed the literature as closely as any pediatrician has. I've published in that, I have presented that at meetings, and so that I am a board certified pediatrician who comes to court to bring the science of relevant to retinal hemorrhaging for the jury to hear, so that they can decide what they think the role of the retinal hemorrhaging is in a case. If they do not hear that, then they have been denied the opportunity, the capacity to hear what the published literature has said about retinal hemorrhaging. And in this area, so that and the retinal hemorrhaging is frequently in the past been asserted as a finding highly almost pathognomonic of abusive shaking. However, the American Academy of Pediatrics has acknowledged that as controversial. They have downgraded the role of retinal hemorrhaging in these cases, and the American Academy of Pediatrics Committee on Child Abuse and Neglect in official position statements has fully recognized that retinal hemorrhages can have many causes, and they have backed off on saying that repetitive acceleration, deceleration is a critical cause of retinal hemorrhaging, particularly when all the research failed to validate that position. As of August in 2018, their position has backed off and changed. So that my role in a case like this would be if an ophthalmologist comes in and were to say that these retinal findings are indicative of abuse, specifically abuse by shaking, then I would challenge that, and I would challenge it with the body of literature and research, biomechanical, animal, and human data, which I'm ready to present in infinite detail, that has failed to confirm such testimony if such testimony were to come forward.
Thank you. Sir, I'm going to try to speed us along. I hope we can talk a little bit about Rourke, and I think I can speed us along. I'm going to ask you a question, which I need to ask you for the record. It's a serious question. It is definitely not meant to be disrespectful or sarcastic. Serious question. In your years testifying, have lawyers ever objected to your answers as non-responsive?
Object, Your Honor, as to relevance and argumentative.
I'm trying to make this as efficient as possible.
I still don't understand the relevance. What is irrelevant?
In that case, Your Honor, okay, thank you. In that case, if I may address the court, I would just like the court to take note that Mr. McCarthy has not objected to any answer by this witness as non-responsive.
Right. And I think sometimes as I'm listening to all of this and we're meeting our marks, I do take the idea of the trial court being the gatekeeper, and y'all are afforded the opportunity to ask the questions, but I don't see it as, at the end of the day, I've got to make the qualifications, but I've got to be satisfied. And so I have the opportunity to ask questions as well, I think. Because if I were deprived of that opportunity, then I'm not truly qualifying the expert. So given that, so I guess what I'm trying to tell y'all is that you can object that it's non-responsive, but if the court wants to hear it because the court needs to hear it in order to qualify him as an expert, I'm listening to every word he's saying.
Thank you, Your Honor. Because of the technical, I'm sorry, they're technical things.
No, and I know. And so if that makes any kind of sense. So maybe, and Mr. Avila, you have a sense of, okay, I understand we could lodge a lot of different objections here. And maybe we're going off on tangents, but at the end of the day, the court has to be satisfied. And so to a certain extent, it's the objections, you can lodge the objections. I need to understand science. I need to make sure that this expert is not going to that this expert is going to assist the jury and not confuse the jury and understand his qualifications, the reliability of the science, and the relevance of the testimony.
and Your Honor, addressing the card, in the last few minutes, I have been able to hear the court pretty well, but
Okay,
I
good.
did miss probably a good deal of what you were saying
In the
a
beginning,
little bit before that.
basically, I'm saying this is a gatekeeping function, right? So honestly, it's really almost, in my mind, to a certain extent, this is the expert that's being put on, but it's almost as if it's my witness. I need to have certain questions answered. I mean, and if necessary, I will ask those questions, right?
Yes,
Because
ma'am.
ultimately,
And I think
so for me right now, I have not found any of his responses non-responsive. Does that and so you just understand where I'm coming from, and not that it really matters,
I think
but yeah, but I mean, honestly, the court has to ascertain for itself whether or not this expert is qualified, and that's not just limited to the questions and objections that y'all make, in my view.
I hear and understand, and I also think you're largely right. And I think I'm going to have to forego some, maybe all of the RARC material and get through this quickly. I do think the court needs to answer or ask the questions that it, yes, I think that's absolutely correct. And the only thing I wanted you to take note of, and I think maybe you didn't hear me or maybe I didn't hear you, sorry, was that I wanted it to be noted that I have not objected one single time on the basis of non-responsiveness. I wanted that acknowledged for the record.
Noted. Thank you.
Sir, we'll get through this quickly, okay? As regards the other disciplines of medicine that may be relevant to this case, and I'll get through this quickly, okay? But help me a little bit, please. Because I think I can make it easy. You have just testified about ophthalmology. Now, as regards radiology, if I ask you if you agree that you are not an expert in radiology, will your answer be effectively the same as the answer you gave about ophthalmology?
I think the best way to answer that is I'm not a radiologist, so it would be effectively the same. But if I start with the reading report in the chart, the words of Dr. Marthy, and then go to the child abuse textbook and match it against what they say in that textbook, then I think I am most qualified. I'm adequately qualified to bring that correlation to the court, so that whether that you say that I'm an expert in radiology or not, but the textbook from the American Academy of Pediatrics, who in this case specifically talks about the timing of blood products on MRI, which is the issue that we're probably getting at in the bottom of this thing, and it says this means that, then I think I am an appropriate witness to bring that to court. And if you're not going to have me bring that to court, then my advice to the defense attorneys will be to call every radiologist who touched this child, haul them into court, put them on the stand, pull up the imaging, point to spot X, and ask them to specifically comment in laborious detail, and not just sweepingly come in and say and sweep it under the rug, because that is an issue that's at the heart of this case.
Thank you for that answer. Thank you very much for that answer. In fact, on all of these questions that we've been talking about, These questions can be brought to the testifying physician by the defense attorney on cross-examination. Do you agree?
I think they might be brought, whether the defense attorney can adequately frame the question. And when the treating physician says, I am not familiar with that article or that research, and that court moves on, then I think the jury has been deprived of information that they need.
On the questions regarding radiology, intensive pediatrics, surgery and trauma surgery, to the extent you can say yes or no or close to that, would your answer be the same on the question of whether or not you're an expert?
My answer would be the same, that my role is to coordinate what is in the record with the published research, and the research is published is for guidance to all doctors across the country, and who choose to read it and engage it, then they should have the capacity and the opportunity to bring that science to the court. The American Academy of Pediatrics says my role is to bring science to the courtroom as an educator of the trier of fact. And so that if a body of research relevant to the case, if I've devoted 20 years of my life to closely following that research, then I am, I think, in an appropriate position to bring that research to the court. I'm not here to say this is abuse or not abuse. That's the trier of facts job. It's my job to match the research with the facts that is out there. And I've for the last 20 years have done the best I can to closely follow the research in terms of shortfalls, chronic subdurals, retinal hemorrhaging, and now the controversy over the biomechanics of shaking.
Okay. We'll try to move quickly. On the subject of the of questioning a physician about scientific findings, I mean, you're aware that if he says I don't know, he can be shown the document.
But you're going to hand him, you're going to hand him,
and be asked to read it.
and you're going to let the court sit there while he spends 4 days reading 5 articles?
No, I'm just saying a defense lawyer could highlight the relevant points.
I don't think that it's not, it's more complicated than that.
Now, your answer to the question just before that, I heard you, and have you, or how many times have you, in a criminal context, how many times have you testified for the prosecution?
I have never been asked to testify for the prosecution. I have, I'm only been approached by the defense attorneys. I have had cases where after I reviewed a case, a conference was set up between me and the prosecutor chose to drop the case and not pursue it. And I have had cases where after I review it, I think I have written a more damning report than the child abuse doctor did. Okay, and been paid for it. I had a case this year where I had to agree totally with the allegation. But since I am only approached by the defense, that if I have nothing relevant to offer, I tell them that, and they don't call me back quite appropriately. I have never been approached by the prosecution as a primary reviewer. The next time you have a case, if you want to engage or retain my input, I'm happy to offer that. But in the last 25 years or 20 years or so, that has never happened because these cases are only coming forward when the child abuse physician at the hospital has raised the concern. And they not only generally only come forward when the hospital child abuse pediatrician has made a determination.
I will forego all the RARIC questions and so forth, but I want to flesh out the CV just a little bit. I got to leave this to the judge most appropriately, but I know you've testified many times. Well, I think you said 8 or 10 times in Texas. So, and understand, sir, I'm not going to ask you to cite chapter and verse, but can you tell me the last 3 times that you were qualified and testified in a criminal case in the state of Texas? I mean, can you tell me what the case was, what the date was, that sort of thing? I don't
No,
need.
I know the case out of McKinney. I don't remember the defendant's name or the attorney's name, but that was out of McKinney, Texas. I testified in that one. That's
Okay, you testified in McKinney?
what?
Yeah, maybe you were going to go ahead and tell me the other
I
city.
don't remember the off the top of my head specific authors and defendants and attorneys.
Okay. Well, you did not testify in Corsicana. You testified in McKinney. I believe you mentioned that you testified multiple times in Dallas County. Is that correct?
I fly into Dallas Airport and get an Uber to a hotel. I don't know the county versus the city, but in the Dallas courts, yeah, I've testified in Dallas going back 20 years.
Okay, so how often in that case, how often have you testified in a criminal case in the courthouse in the city of Dallas?
I can't answer that. All I can tell you is I wouldn't recognize the courthouse in Dallas because I don't live in Dallas. I fly in, I get driven to or drive myself to a big building that looks like a building, and then I testify, and then I leave.
Okay.
I don't know how to answer your question there. I think if you have research, you could possibly correlate expert testimony in cases in Texas, but you have that capacity that I'm not here to give you.
Thank you for that comment. Could you just try to remember, since you said it was 8 or 10 cases, could you try to remember the airports that you flew into in Texas for that purpose?
Oh, well, from Alabama, I've driven into certainly East Texas. I grew up in the Houston Galveston area. I think I drove to Corpus Christi. I think I have driven to Dallas several times, flown to Dallas. I was flying into Fort Stockton, and the case settled while I was mid-flight. That was this year. And so I don't track that way. I'm sorry.
Okay, then there's just one more question on that. Are there any other Texas cities that you remember going to testify in a criminal case? Are we having 10 minutes? Did you hear?
Somewhere around Temple, Scott and White cases I've testified for at least that was the accusing hospital, Fort Hood's in Texas. Yeah, I'd have to. I have no capacity. I guess I could go back and look at. I don't know. Are you looking for cases to look for my testimony, or what? I don't know. Can't answer. Can answer to your satisfaction.
Okay. And this is the last question on the cases. We talked about the New Orleans and Corsicana, and I believe you testified that you've been disqualified or not permitted to your recollection 4 times. That was your testimony.
Mhm.
Was that right?
That's to my recollection.
Okay. Do you recall where the other 2 cases were besides New Orleans and Corsicana?
Nashville. And since then, I've had a case in Nashville where, after consulting with the prosecutor, he chose not to pursue. So that I mean, I'm surprised that I keep getting calls from the Nashville area.
New Orleans, Corsicana, Nashville. Do you know the 4th?
Twice in Nashville.
Okay. All right.
And that goes back 10 or 12 years, I believe, to Nashville.
So I'm looking at your resume, I beg your pardon, your curriculum vitae. And so I just want to get the publications right, okay?
Sure.
So you've got 3 publications here, right? Listed. I mean, these are like scholarly publications. Is that correct?
Yes, in peer-reviewed journals.
In peer-reviewed journals, correct. Okay, so are those the 3? I'm sorry. Are those the 3? I mean, those are the 3 that I need to look at if I want to understand what you're saying. Is that correct?
Those are the 3 that I published. Of those, I think the first one is not relevant to this case. The second one has some relevance to this case. The third one has a lot of relevance to this case. Those are the primary articles. If you then go down below it to beyond presentations, to the second page, letters to the editor, if you go through that, there's a number of those that are relevant to this case, and they are editor reviewed as well. They're not automatically published, and so that's the risk of about the 5th one down is injury risks of feet first falls of a 12-month-old, implications of injury and perpetrator identification, challenges to the vitreous retrotraction hypothesis, on retinal hemorrhaging, increased intracranial pressure and retinal hemorrhaging on the next page, another retinal hemorrhaging, another thing associated with let's see, bleeding disorders, patterns of retinal hemorrhaging, mimics of abusive head trauma response to 2016. Those are my areas of.
And these are letters to the
print.
editor.
Yes, but they're not just automatically published, remember. He sends them to the author of the article being commented on. There's a discourse that goes back and forth. And then the editor chooses whether he thinks it is a piece of writing which advances our understanding in an area, so that they are very much out there.
Okay. And finally, on presentations, these are oral, these are talks or lectures or.
Yes, I stand up in front of a crowd, present a lecture. 2 of the one in North Carolina and Oklahoma were for SEA continuing legal education credit. So that those are lectures that I've given.
Okay, so none of under presentations, because I get confused sometimes, none of those are posters. Is that correct?
Oh, correct. Those are I'm standing up for an hour, showing slides and presenting the relevant research, much like I do to the jury, particularly in terms of the retinal hemorrhaging issue, and to the Oklahoma defense lawyers. We went through all of the retinal hemorrhaging literature, all the shortfall literature, and all the biomechanical literature relevant to shaking.
Okay.
And through that lecture, I also traced the positions of the Academy from 2001 to the present in terms of the evolution of their positions and how that has evolved over time.
Do you charge hourly or in some other fashion?
I prefer to charge on a flat rate. I usually request $3,000 for review and consultation.
If we're getting into payment and all that, I don't think it's relevant. It's outside the scope of this hearing.
Charges, I don't think.
Leave it to the discretion of the court. It's certainly be irrelevant before a jury.
Hold on. I'm gonna overrule it. Only as to what he charges. That's it.
Judge, I didn't catch that. I'm sorry, I was muted.
Only as to, I'm gonna overrule the question, but it's only as to what he charges, and that's it. Not as to who pays what or anything of that nature.
So,
Can I answer? Or is that
yes, sir. That my understanding is you can
okay?
answer the question.
Texas pays on a flat rate. I request $3,000 for review and consultation, and then if testimony is ultimately felt to be helpful to the court, I simply charge $1,000 for my time, which could be up to 4 days, as I fly in, spend 2 days, and fly out 4 days for my time involved in testifying. That's not per day, that is per total, and that my travel expenses be covered.
And I guess my final question, and this is a hypothetical because we don't know the court's questions or determinations. Were you to be qualified to testify? We were talking about defense lawyer or lawyers and so forth. If I worked through the defense team, would you be willing to review something I might want to send you to comment on?
Object, Your Honor, as to speculation, relevance, that.
I think that was more a question to you, Mr. Avila, and you, Mr. Shelley.
Oh, I thought he was asking the expert, Your Honor.
Well, essentially, he was asking the expert, but it really is your call.
I withdraw the question.
I mean, if it's something that's going to advance the case, I mean, it's up to y'all. But if it's, I don't know what Mr. McCarthy has in his head.
Oh, I see what the court is saying. I understand.
So that's something y'all can discuss between yourselves.
I agree.
I don't think I need to be part of that conversation.
I've withdrawn the question. I withdrew the question. It may not have been heard. All right, I guess we won't talk about RARC, or well, maybe we will, but not for me.
You can. In regards to that, Mr. McCarthy, ask your questions in regards to that case. Right now, for me, I have questions regarding reliability, but I don't have any. I'm not concerned about qualifications. I'm not concerned about relevance. I'm a little more. I don't feel completely educated is the word I'm looking for, informed as to the reliability. I don't know if that helps.
The state will pass the witness.
Mr. Avila?
1 brief second, Your Honor. Regarding the court's concern, I do want to address a couple of things with Dr. Galasnik, and I am 100% sure the court's going to have its own questions. So I'll try to be brief, or as Mr. McCarthy would say, final questions. The Dr. Galasnik, when we're talking about the abusive head injury, the reason we call it abusive head injury is because it's non-specific as to whether it was accidental or not, correct?
The word abusive, yeah, it means whether it's accidental or explained by a medical, whether it's accidentally could occur or medical problems could explain it, versus an abusive would be an intentionally inflicted act. Again, you can bump a head accidentally, you can bump a head intentionally. One would be abusive, one would be potentially an accident. So the word abusive head trauma, the word abusive as an allegation means that it was intentionally inflicted as opposed to accidentally inflicted. In terms of head trauma, just means anything to the head. A lack of oxygen to the brain is head trauma. So that in terms of the mechanical infliction of abusive injury in these kind of cases, you're generally talking about either impact or an allegation of shaking. And the shaking allegation, of course, since 2009 has been recognized as controversial. So that, and nothing on physical exam is going to tell, nothing on imaging, nothing on physical exam, and nothing in laboratory is going to tell an accidental head impact from an intentionally inflicted head impact. That falls to the trier of fact. What people like me bring to the court, or what the biomechanical engineers can investigate and publish in reproducible experiments is are the levels of force that can be generated in a specific impact, a 1 foot fall, a 2 foot fall, a 3 foot fall. Do they rise to the levels of what would be predicted to cause a given finding? That's all they can bring to a case. They can't tell you whether it was accidental or whether it was intentionally inflicted. And the same is true for the skull fracturing research. How much impact does it take to fracture a skull? And the same thing goes for the research towards what can actually be demonstrated by mechanical forces to produce retinal hemorrhaging. They can't look at any hemorrhage and say this is abuse or this is not abuse. What they can say is we have either valid science saying event X can produce this, or event X has not been demonstrated to produce this in a situation. And that's what all of us who look at these kind of literature and research are focused on. It's not my job to say whether the fall event did or didn't occur. It's not my role to say it. I'm here to say it was definitely that. I'm saying the history that's in the chart is that. So my role is to address the science and the research so that if it occurred, what might be the results. And then the trier of fact, armed with that research, can then choose to what kind of decision to make.
Galasnik, please excuse this ignorant question. This is coming from someone who doesn't have a science background, but you know the research and the literature behind abusive head injury, abusive head trauma, or what was formerly known as shaken baby syndrome. That has been, is it a soft science or a hard science? Is it something that you can verify, that you can verify the validity of it?
Yes, in terms of you can take a model, you can measure the forces in shaking it. You can then match that against human data to see if those forces would be predicted to produce that. That's precisely what's in my report in this case. It is falsified, it is published, it's testable, and it's falsified. What is not Dalbert worthy is a subjective opinion by a doctor that this was abuse, or was not abuse. To say that we looked at 100 cases that we thought were abusive and we saw retinal hemorrhages in 80% of them, that is not scientific, testable, falsifiable research. That is subjective clinical supposition. And so then, and again, I harp on this, but Dr. Robert Block, incoming president of the entire American Academy of Pediatrics in 2010, stood up at the National Shaken Baby meeting and said, valid causation must be able, that can demonstrate that it can cause a finding, and it did cause a finding. And since 2010, we have had some very focused efforts trying to demonstrate what certain alleged mechanisms of injury might or might not do if they were to have been if they were to have occurred in a given case. That is published, it's testable, it's falsifiable, and if anyone is not liking the results of that research, then they have the parameters where they themselves can repeat that research and see if they themselves get different answers.
The technique as to how you approach these kind of cases supported by the literature in your field of expertise in pediatrics.
Yes, I'm approaching this precisely that way. I start with a differential diagnosis that matches the known history and facts of a case, and then I start looking at the research to see what might apply and what might be supported and what might not be supported to come to an opinion at the end. And at the end, my opinion is probably not going to be this is definitely abuse or this is definitely, my opinion is it is either consistent with or consistent with both abuse and non-abuse. That's frequently where we can end up. Or I can say that I can't say it's not abuse, but in this case, if the allegation is abusive shaking, then I would have to say that I frequently could get to the point of saying that the findings in this case would not be consistent with that allegation. Does that make sense or not? I may have confused you there, but
it makes perfect sense. And that is why, based on your research, you talking with consulting with other perhaps radiologists, ophthalmologists, this kind of approach that you take, it does rely on established principles of pediatrics as well as other research that you've done, correct?
correct. I think that the idea of a differential diagnosis is standard medicine. The idea of this kind of research as scientific experimental is the basis of all science across the board. In the high school science project, you start with a hypothesis and you don't believe the hypothesis forever. You have to test the hypothesis to prove it either valid or not valid. A ludicrous example would be if your science project was to determine whether lima beans germinate faster to rock music versus opera, then you set up your petri dishes and you try to demonstrate that such a thing makes a difference. And in terms of that is scientific research. That's what the biomechanical engineers are doing, and in coordination with pediatricians, and that's what they are publishing. That is published, peer-reviewed, testable. You can repeat the test that they did, and you can falsify it if your results are different.
Hey, Dr. Glasnick, is this approach that you take consistent with a validly acceptable approach on pediatrics in your field?
Yes, I think that's what we do. I mean, if you got cancer, you want to be treated with demonstrated therapeutic benefit, and our knowledge is always evolving. What we thought in 2001 changed in 2007, changed in 2009, changed again in 2010, 2015, 2018, 2022 is the sweep of the evolution of the positions from the Academy of Pediatrics relevant to this area. That's
And
what I
Dr.
lecture on.
And Dr. Glasnick, when you analyze imaging or perhaps medical reports talking about, for example, a subdural hematoma or retinal hemorrhaging, are the techniques that you apply in analyzing those consistent with your experience, the literature, and the peer review or your consultation with other branches that you've gone throughout your field?
Yes.
Okay. Um, 1 second, Your Honor. At this point, Your Honor, I pass once.
Any further questions, Mr. McCarthy?
Sorry, Judge, can you repeat that?
Any further questions, Mr. McCarthy? Did you hear me?
Yes,
Yeah.
ma'am. No further questions, Your Honor.
All right. Dr. Glasnick. You recently, and you point to, and it's in your CV, made a presentation on controversies in abusive head trauma to the Oklahoma Criminal Defense, I think it was, right?
Yes, ma'am.
Is it possible for you to, and I don't know if it was a PowerPoint or if it was a paper, but is it possible, if I'm hoping it's a paper, for you to forward that to Mr. Shelley so that I can read that?
Absolutely. What I can forward you is the outline of my presentation, walking through the literature. I also provided to them and as handouts what I call my paradigm shift in terms of the research on retinal hemorrhaging and the paradigm shift on our understanding of shortfalls. And that was information that was offered to all those defense attorneys at that meeting. I'll be glad to send that to you. I send it to the attorney and they can forward it on.
Right. Yeah. If you could do that. This is and I think hopefully you'll understand, one of the questions that the court has is how reliable is the science that you're going to be opining on? And you just answered that this as most science, it's evolving. The positions have changed, maybe radically, especially, I think you're especially talking about shaken baby syndrome. You said 2009, 2015, 2018, 2022. Given the evolving as we speak kind of thing, it counters to me, for me anyway, the idea of the reliability of the science, because it's relatively new in terms of science, right? We think of science being a humanity's pursuit over hundreds of years. So be that as it may. So that's why that's very important to me, is because I do want to know about those controversies. If your paper addresses that, I don't know, in regards to the science of head trauma. I understand that abusive head trauma implies obviously some kind of intent and non-accidental. Let me put it that way. Not an accidental head trauma. The other kind of question I have is, amongst pediatricians across the United States, do you feel like most pediatricians still recognize the validity of shaken baby syndrome?
Let me answer that a little bit to get to the end point on that. There's about 60,000 pediatricians in this country. If there's about 1,000 of these cases per year, most pediatricians in this country have no reason to even think about this issue. They can have a long career, 24/7, answering the phone in the middle of the night, and never have a case like this come forward. Of the pediatricians who have chosen to look at the literature, the American Academy of Pediatrics in 2009, an official position statement, which I cite in what I'll be sending you, acknowledged that the shaking mechanism is controversial, and that there was no valid science backing it up. And that's when they recommended the evolution to the term abusive head trauma to be nonspecific for mechanism. And so that term is that abusive head trauma doesn't tell you how it might have happened. So that of the pediatricians who have bothered to had a reason, I'm not saying that derogatorily, I'm just saying they had a reason in their career to look at the literature. Since 2009, this has been recognized controversy. And again, I think the big paradigm shifts from my point of view, from a retinal hemorrhaging point of view, was August of 2018, and from a short distance fall point of view was December of 2018, and that will be laid out in what the attorneys can forward on to you.
Yeah. So as a rule, I know that you've qualified it, but in the field for pediatricians, it's probably not penetrated the field substantially or materially that shaken baby syndrome is no longer a scientific, doesn't have, according to y'all, have scientific validity, according to the American Association of Pediatricians.
Right.
Okay.
As of 2009, the American Academy of Pediatrics recommended the term not be used at all in the medical record. And if it's not good for the medical record, it's not good for court. That was 2009.
I understand. I understand. So and just so that just so you understand, I'm asking questions of you in a vacuum because I don't know the facts of this case. I think I've looked at the indictment. Normally in these kinds of cases, you have the accused and the child. I'm not going to say victim because victim implies, non-accidental. But they, I always think of it as they go into a black box, they come out, we don't know what happened, right, in the black box. It's either accidental or it's non-accidental. And so you're going to be looking specifically, based on what you've testified today, is my understanding, you're specifically going to be looking at the science in terms of the medical science and the results of the imaging and et cetera. And you did say medical records to arrive at a conclusion or opinion based on, was it accidental? Well, not that it was accidental. What you said alternative. I'm going to use the word theories in which those injuries could be sustained, because I'm assuming that even in a biomedical way, if you take a child's head and if you intentionally hit it with an object or have it cause it hit an object, the force is the same, depending on the amount of force that's used, the force is the same to a certain extent if you fall from a certain height, right? I mean, the intent doesn't the force that's exerted doesn't give us a bright line rule of whether it was intentional or not, right?
Absolutely right.
No?
And then a head that doesn't know if it's been hit accidentally or intentionally. And my testimony would come down to say that the findings in this case would be consistent with a head impact of as little as this. Now, whether that actually occurred whether it's occurred accidentally or whether it occurred intentionally, is nothing I make any pretense of bringing to the court.
Right. And that's my understanding, is that you can say these injuries occurred based on all of your experience and knowledge and etc. because this amount of force creates this kind of injury. Whether that force was accidental or intentional, you cannot opine to that unless of course, sometimes, I mean, if it's kind of like, if I always think of the example of, you're in an airplane, everything's fine, and somebody says, well, you need to jump out. And you're like, well, wait, I need more information, right?
Yep.
So then say, well, the plane's on fire. Well, then, okay, well, maybe I'll think about it. You have a parachute. Yeah, I have a parachute, the plane's on fire. And now they told me we're still on the ground. Okay, I'm jumping out, right? So when we add up those different, and I think that's kind of what I think that's what Mr. McCarthy was trying to talk about. It's the addition of those kinds of facts that usually the investigation talks about in terms of, opportunity, and you talk about demeanor and credibility and all those other things, which I don't think anybody is asking you to opine on. Your sole purpose, the way I understand it and see it, is to go and just based on the imaging and the medical presentation of the child as to the force and the possible different ways. I mean, obviously, you could take a head and drop it on the floor. You could take a head and it could fall against the wall. All of those kinds of mechanical, physical, physics kinds of questions in regards to the outcome when biological systems and processes and tissue encounter, like in car crashes, encounter hard substances and those kinds of things, or whatever the case may be, right?
Right. And I'd like to, I specifically state, as frequently I can when I testify, or talk to the attorneys, is I want the records, I want the imaging, and I want the history that comes with the chart. I specifically do not want to look at the witness statements, an interview of the neighbor, whether there's a meth lab in the neighbor's garage, or whether, because that is not what I have the capacity to deal with or bring to, and my goal is not to ultimately make a decision, is this abuse or not abuse? Someone has to do that. But as an out-of-state person coming in from the outside, that is, I've got no more capacity there than the jury does. Let them hear the interrogation tapes.
No, that's the jury call. I mean, at the end of the day, the jury listens to all of the lay witnesses to make a determination whether somebody was acting what we call consciousness of guilt and those kinds of things. But the science is very important. And I like I said, I don't know whether this is a shaken baby or whether this is an impact case only, or if there, normally what prosecutors do is because somebody was alone with a child comes out after being alone, there are these injuries, and so out of an abundance of caution, they will allege everything because they don't know how it happened, whether it was impact or shaken baby. And so and so those kinds of that's so generally they allege every possibility because you don't know, right?
Right.
So to cover their bases, and I don't know, like I said, I don't know anything about the facts of this case. I know I've read the indictment, but I don't even remember what it says at this point. Okay. I think that's I am going to read the Rourke case, Mr. McCarthy, again. if there are any questions in regards to that case that you want to specifically address with Dr. Golaznik, I think now is your opportunity.
Thank you, Your Honor. Thank you in one moment. Okay. To the extent that you can answer yes or no, please do so. You agree that Rourke is not that I beg your pardon. Do you agree that this case does not have a defensive theory of rebleed?
The current case?
The
case that
the present case, our case right today. Yes, sir.
Without going into a lot of details, I don't know that I can answer that. Because Dr. Morthy's reading of the MRI of the 31st specifically said early and late subacute blood product. Late subacute is greater than 7 days, and the MRI in question was done at less than 48 hours after presentation. So that's Dr. Morthy's reading, his words matched against the published timing criteria on MRI. So that is so that whether you say that blood product that he was seeing.
I got kicked out of the Zoom, so since you all started questioning, I didn't get any of that.
Oh, okay.
The last thing I got was thank you, Your Honor. One moment by Mr. McCarthy. So
Okay. I think Mr. McCarthy remembers his question.
Okay.
So I'm going to have you, Mr. McCarthy, repeat the question. I feel like we're given a play and now we got to, like filming. Like, that's what they do in Los Angeles. They say cut and then actors have to do it all over again. That's what we're doing. Anyway, I'm going to call your question if you don't remember, Mr. McCarthy. So ask your question again, and I think Dr. Golaznik was explaining his answer, and we'll do it again for
sorry.
you. Director, you're now the director. All right.
Okay, yes, ma'am. So the court's asking me to re-ask a question. I will. I think that my question was, do you agree that the present case, the case of against, or the accusation against Mr. Rodriguez here, does not have a rebleed theory of defense?
I
know Dr. Golaznik responded to this, but
That's
I have an issue with just going into the specifics in this case. This is clearly outside the scope of the 702, 704. Okay.
I've withdrawn the question.
Your initial question was different.
I did my best.
It's tough. It's just tough. I don't know what to say.
First question, it didn't draw an objection. The first question was, I think, fine. Whatever.
I would comment, though, I did not specifically review the details of the original presentation of the Rourke case coming into today. I know the decision, and my testimony that I think was back years ago, so that if you want to discuss the Rourke case's specific details as opposed to the ultimate rulings, I'm not really prepared to do that. I just know that the rulings and the decisions that came down in the Rourke case appeared to be closely relevant to some of the issues in this case. So that's as far as I'm ready to go down that rabbit hole today.
Thank you. Pass the witness.
I have no questions, Your Honor.
I don't mean to kick the can down the road, but I would like to review, Dr. Glasnick, what you're going to send me and some of the cases. I think there's some other cases. There was I don't want to say companion case, but there was another case that that kind of at the same time that Rourke was issued, it was I think State versus Wolf. I just got that case. They denied I think the writ in that one because they found that the medical issues that were in Rourke were not implicated in State versus Wolf. So I do want to have an opportunity to look at all of those cases. I will note that all of those cases talk about the evolving new science and the basis for shaken baby. And so, but I think that's only pertains to shaken baby. I don't know if this case is only shaken baby or if it's shaken baby and impact or impact only. I don't know because I don't know. Y'all know this case better than I do. But at any rate, I'm going to review that and I will give y'all a decision next week. I'll work on it.
Thank you, Judge.
All right.
Thank you, Judge.
You're very welcome. It's still light outside. I want y'all to know it is pitch black. It is pitch black where I'm at. You know, the sun sets over here at like 4:15.
Because you should actually be on Atlantic time.
Yeah, I'm actually, I'm on Eastern Standard, whatever it is. But anyway, I look forward to seeing you all again tomorrow morning and your bright and shiny faces. And we'll get to do this. We'll get to have a fun time all together again tomorrow morning at 9 o'clock. And thank you so much for your time, Dr. Glasnick. You really educated me this afternoon, and I appreciate that.
Okay, have a good day, folks.
Likewise.
Thank you.
All right.
Can I get Dr. Glasnick's CV, please?
CV, yeah, they just it's floating around.
Okay.
And I'm going to
Ms.
send my presentation materials to the attorneys.
Yes.
All of the defense attorneys in Oklahoma have them. You can even have them too.
and yeah, if you can get a copy of all of that to me and Mr. McCarthy, I'd appreciate it. And can somebody be sure that Dr. Glasnick's CV gets sent to Ms. Contreras?
Yes. Can Ms. Contreras can you write down my email? I don't have your email. What is your email?
Yes.
I just emailed it to you, Ms. Contreras. Sorry, in the midst of all this conversation, I emailed it to her, and I CC'd everyone, so we're good.
Okay. All right.
Thank you.
All right. Then we're good. All right.
Okay.
There we go. Well, have a good
Thank
rest of your evening, everybody. Thank
Thank
you,
you.
Dr.
Okay.
Glasnick.
You too, Jen.